Good afternoon and welcome to the 2020 Commemoration of Law Day. My name is Jane Sanchez and I have the honor of serving as the 25th Law Librarian of Congress. It is my pleasure and privilege to greet all of you on behalf of the Law Library of Congress and the American Bar Association. Both of us are joint hosts in our first time ever virtual celebration of Law Day. With the pandemic affecting the way we work, interact, and live, I am very glad to see so many of you in attendance today. Thank you all for joining us. Law Day is a national day to celebrate the rule of law and its contributions to the freedoms that we as Americans enjoy. A day aimed to promote and remind all of us how to appreciate the freedoms that we enjoy, the liberties, and also to cultivate respect for the law, which is vital to the democratic way of life. And the 2020 Law Day program this year is titled Social Movement Changing America, the Legacies of the 19th Amendment, and this year's Law Day theme is Your Vote, Your Voice, Our Democracy, the 19th Amendment at 100. Our theme also dovetails very nicely with the Library of Congress's exhibition, Shall Not Be Denied, Women's Fight for the Vote, which celebrates the ratification of the 19th Amendment. Women's suffrage has had a profound impact on the America in which we live. The movement opened so many doors for women and allowed them to achieve a greater role in society. It changed our society, how we see and understand democracy, and most importantly, I believe it inspired other constitutional changes and reforms. Law Day 2020 offers the opportunity to explore the 19th Amendment from its creation to its impact over the past century, its complexity and its legacies. As a women's rights pioneer and a leading suffragist and abolitionist, Lucy Stone once said, "Now all we need is to continue to speak the truth fearlessly, and we shall add to our number those who will turn the scale to the side of equal and full justice in all things." This event is our small contribution to her words and the Law Day tradition. Once again, thank you all and enjoy today's event. And as this concludes my section of welcome, I now hand the mic over to Judy Perry Martinez, President of the American Bar Association.
Well, thank you, Joan. And the American Bar Association is thrilled to be sponsoring this event with the Law Library of Congress and continuing our work throughout the year on our Law Day theme of Your Vote, Your Voice, Our Democracy, and the 19th Amendment at 100. Law Day has been commemorated by the American Bar Association since 1958. And as Jane said, its purpose is powerful in that it helps us really focus one day on the importance of understanding the rule of law and also gaining a greater understanding of what our laws are about. We thank the Library of Congress for its work in continuing these efforts and joining us on this virtual platform. And we thank our audience for joining us from your busy days. Our program is about to begin with an extraordinary group of panelists, but first let me begin by introducing our moderator. Kim Atkins is Senior Correspondent at WBUR in Boston Public Radio and an on-air contributor to MSNBC. She currently serves on the Advisory Commission of the ABA Standing Committee on Public Education. Our panelists include Martha Jones, who is the Society of Black Alumni President, Professor at Johns Hopkins, and author of the forthcoming book, Vanguard, how Black women broke barriers, won the vote, and fought for rights for all. Our next panelist is Tom Saenz. He's President and General Counsel of the Mexican American Legal Defense and Education Fund. And Julie Suk is Professor of Sociology, Political Science, and Liberal Studies at the City University of New York Graduate Center and author of the soon-to-be-published book, We the Women, the Unstoppable Mothers of the Equal Rights Amendment. So we have an extraordinary panel of experts and a terrific moderator who will take us through this journey about the 19th Amendment and what it means today. So it's my pleasure to turn this program over to Kim and to thank all of our panelists and Kim for this extraordinary event that you're about to be a part of. Thank you.
Thank you, Judy. Thank you so much for allowing me to be a part of this, and thank you to our esteemed panel for taking the time for this discussion today. And I'd like to jump right into this discussion by asking all of you to listen to and consider this quote from 1776 from John Adams, and that's where our discussion will begin. I'll read it. It is dangerous to open so fruitful a source of controversy and altercation as would be opened by attempting to alter the qualifications of voters. There will be no end to it. New claims will arise. Women will demand a vote. Lads from 12 to 21 will think their rights not enough attended to, and every man who is not a farthing will demand an equal voice with any other in all acts of state. It tends to confound and destroy all distinctions and prostrate all ranks to one common level. I want to begin by asking our panelists to comment on that. What do you find so striking about that quote and what it says, what John Adams intended it to say, and how it might fall on our ears today in 2012? Martha, why don't you start?
Sure. I also want to just say thanks to the ABA and the Law Library of Congress for convening us. I think there's so much that's important in this quote. On the one hand, we recognize the tension that federalism presents in the United States. Are voting rights the purview of the central national government, or are they the purview of the individual states? That's a question that remains with us until this day. I think the other piece that's important is that, in a sense, Adams is right. That the question of voting rights, dangerous might not be quite the word I would use, but the question of voting rights is a troubled, troubling, fraught, and recurring matter in American history from the founding era, again, until our own time. It's difficult to point to any moment in the U.S. past when we are not, in fact, grappling over, disagreeing about, and wrangling over who has the right to vote, by what terms, and by what means. The last phrase, one common level, I think is one I'll take away from this, which is to say, I think here Adams intends that to be a sort of pejorative, the notion that we would all be at one common level. And it may be that phrase alone, we see how far we've traveled in our sensibilities about voting rights, as today the call for universal voting rights, while not embraced by all, is, I venture to say, a majority view in the U.S.
And Tom, I want to go from there. You know, the quote, no end of it. It seems that he was describing some sort of Pandora's box where just anyone would be able to vote, and that perhaps wasn't the intent of the framers. But, you know, when you think about it, no end of it. Should there be an end of it when it comes to something as fundamental as voting rights?
No, I don't think there should be, and I think that's what's so, in a way, shocking about this quote. In this day and age, we're so used to lionizing quotations from our founders. We're so used to future-oriented statements from our founders, and this is the opposite. It really is an indication, I think, of how singular an achievement the 19th Amendment, but really all of the amendments and other legal developments that have expanded the franchise are. It's also, because it goes back to our beginning, a reminder of how long the struggle was, especially if you understand that it continues today, as we all do, how long the struggle was to get to a point of including a broader electorate. And that struggle continues, as you suggested, Kim. We really do want to get to a point where everyone is able to participate meaningfully in our elections. And the 19th Amendment 100 years ago was one critical step on that journey, but a journey that we continue now over 200 plus years from when John Adams made that statement.
Yeah, and Julie, Tom sort of was anticipating my next question, is that we think about this idea of universal suffrage as being a part of the fabric of our country, but it's relatively new in our history, right?
Well, it is relatively new, and when I read that quote from John Adams, of course, I can't help thinking of the letter that his wife Abigail wrote to him in that same year, 1776, shortly before the Declaration of Independence was signed, where she said, remember the ladies, and she said, remember all men would be tyrants if they could. And she warned him, as she knew that they were contemplating a new code of laws for the nation, if particular care and attention is not paid to the ladies, we are determined to foment a rebellion and will not hold ourselves bound by any laws in which we have no voice or representation. So the idea was there in 1776 of this fundamental problem that there's constitution making and we the people are making a constitution, but within that we the people are those who actually have voice and representation and those who don't. And I think the process by which the Constitution has been amended, including with the 19th Amendment, relatively new, that is 100 years in a much longer history of this nation, but not new because it was an idea and a paradox that was present from the beginning.
And I want to pull up the slide about the Women's Hour, the poster of the Women's Hour from 1917, and have that in mind as we talk about the next issue is sort of the 15th to the 19th Amendment. When we're talking about voting rights, I would like to get a sense of how the 19th Amendment was shaped by the 15th Amendment, how the rights for women to vote was aligned with racial equality, and places where there were tension in that ideal as well. Julia, I'll go back to you first on this one, but I do want to hear from everybody, so feel free to jump in too.
Well, I want to say two things, which is that the 19th Amendment would not have been possible without the 13th, 14th, and 15th Amendments. Those were important amendments that were revolutionary in that they expanded the boundaries of the political community, the we the people. And so they proved that it was possible. But on the other hand, the 14th Amendment was the first time that the Constitution inserted the word male to the Constitution to describe who was assumed to be a voter, right? And this then led to this problem, can women vote? And it was argued that the 14th Amendment actually included women, but the case of Minor versus Happersett in 1875 made it really clear that even if women are included in the 14th Amendment, it does not include the right to vote. And certainly the adoption of the 15th Amendment brought this issue to the fore, and I think there was a split between the suffragists about the inclusion of women in voting rights when the 15th Amendment was adopted. And I think that that division really continued to plague many aspects of the suffrage movement through the passage of the 19th Amendment. And I'm sure that Martha Jones also has many more nuanced things that she can add to what I've already said.
Well, Martha, going to you, I want to get your views about what the Women's Hour means, what it meant at that time. What does it mean as part of this discussion?
I read the phrase "the Women's Hour" as a direct strike or counter to the 15th Amendment, which had been ratified in 1870 and had been intended to ensure to African American men the right to vote. Now, that, of course, by the time this particular image is created has been scuttled by Jim Crow laws, poll taxes, literacy texts, lynching, have deprived Black men of the voting rights guaranteed to them by the 15th Amendment. But the Woman's Hour, the phrase, harkens back to debates among political allies in the 1860s, an old community of abolitionists and women's rights proponents who were gathering to talk about the future of American political culture in the wake of the Civil War. And there is indeed, as Julie pointed to, a debate about not only the principles, but about what is pragmatic politically, what is possible in the 1860s vis-a-vis the expansion of voting rights. Wendell Phillips somewhat notoriously remarks that it is, after the Civil War, the Negro's hour, and by that he means African-American men. This poster sort of calls into being the woman's hour, and I'd venture to say here that is a qualified woman's hour. It is intended to speak most directly to the interests and the voting rights of white American women. African American women, for example, as you might gather, are in danger of falling out of this discussion, a sort of parody of political culture that posits white men, Black men versus white women as the critical nexus. And African American women by this time will, of course, be organized in their own political movement, organizations like the National Association of Colored Women, speaking their own ideas about what today we would call a kind of intersectional vision of American politics that rejects both racism and sexism simultaneously.
Tom, I'd like to hear your views too about that intersectionality and how difficult it sometimes is today, and sometimes it seems it has always been.
I too, as a voting rights lawyer, of course, my reaction is that the 15th Amendment basically was in effect during Reconstruction, and after that, not really. In effect, the guarantee was meaningless, and it really took the civil rights movement in the mid-20th century and the Voting Rights Act of 1965 to begin to make real what was promised in the 15th Amendment. So it makes me wonder how many folks, both men and women, would have evaluated the proposed 19th Amendment, understanding that a prior guarantee of an expanded franchise was never made real. So in some ways, the 15th Amendment was, in the time that we're looking at, just words on paper, and obviously an important paper, the Constitution, but not something that was meaningfully being implemented. And how many would have evaluated the proposed expansion of the franchise to women in light of that ongoing history? And of course, we know that no matter what it is, including something as controversial as the 15th or 19th Amendment, it takes work. Even after you achieve the change in law, it takes ongoing work to ensure implementation, particularly in parts of the country that are most resistant to that change. And we see that today. We know that the struggle that epitomized the 19th Amendment continues. From the perspective of the Latino community that I represent, it's obviously very important that Latino women have the right to vote, but we still have yet to see Latino women achieve election to offices of importance. I'm struck by the fact that we've had in our history one Latina senator in the U.S. Senate, and she just took office in 2017. In our history, we've had only two Latina women as governors of our states. So the expansion of the franchise on paper is just the beginning or the middle point of a long, long-term struggle extending back to the founding era, as we've heard, and really continuing to today when we have so much work to do, particularly for women of color and on behalf of and by women of color, to ensure that that vote translates into positions of authority and influence in our country.
Well, Tom, I want to follow up with you on that and ask the question to you and to the other panelists too. What did the 19th Amendment do? I mean, as a journalist, I feel I spend a lot of time explaining what different amendments to the constitutions or laws actually did. What did the 19th Amendment do, and what were its goals, and were they realized?
Again, I think that any amendment like the 19th does not immediately realize its goal. The goal here was to ensure that women could vote across the United States. There were already, as you know, a number of states, I have to say, as a California, particularly in the western part of the United States, that had extended the franchise to women. But the goal of the amendment was to ensure that women would have a vote across the country. But more deeply than that, it has to be a meaningful vote. And for it to be a meaningful vote, it means that not only has it to be on paper, women actually have to have the ability to go to the polls and vote. And at least initially, women were not turning out in the numbers that one would expect from the population. Of course, now we have women turning out in greater rates than men. And that's an important achievement tied to the 19th Amendment, but certainly not immediately realized by it. So that's just a measure, I think, of the ongoing struggle involved here.
Yeah, Julie, what did the 19th Amendment do?
Well, I think from the beginning, the movement for women's suffrage was always about much more than the vote. And in part because women wanted the vote, not just to be able to vote, but to have some actual political power to change laws that affected their lives. And that's why the suffrage groups actually didn't fold after the 19th Amendment was ratified. They kind of reorganized and morphed into new organizations. And those new organizations did actually get a few things done in the 1920s. The National Women's Party, led by Alice Paul and Crystal Eastman, started drafting the Equal Rights Amendment because they believed that in addition to the vote, you needed legal reforms that would get rid of other forms of discrimination against women. But that wasn't the only project. In fact, a lot of the other women's groups did not focus on the ERA. African American suffragist Mary Church Terrell attended a Women's International Peace Conference in Zurich in 1919, around the time that the 19th Amendment was being sent to the states for ratification. So there was also a women's peace movement following World War I that was very important. And then, very importantly, a lot of the women's suffrage groups formed the Women's Joint Congressional Committee. And one of the first things that they got done very shortly after the 19th Amendment was ratified was legislation on maternal and infant health called the Shepherd-Towner Act. So there were various agendas that where the vote was seen as both symbolic and instrumental. They really wanted political power to make a lot of changes, but of course women were diverse and had many different interests in different kinds of legal and political change.
Martha?
So I'm going to take us to this slide and ask us to do just a little close reading of this amendment. Right? Shall not be denied. I'm sorry, I've got wrong slide, but that's okay. It's important to say that the language here of the 19th Amendment parallels precisely the language of the 15th Amendment. When Elizabeth Cady Stanton drafts this, she does that quite intentionally. But in both instances, and sometimes our language understandably sort of slips into the mode of guaranteed or promised the right to vote. But in fact, neither of these amendments guaranteed any American the right to vote. It simply prohibited the individual states from using first race and later sex as voting criteria. But as we know, this guarantee that states will no longer use sex to deny the right to vote did not prevent, for example, Southern states from using literacy tests and understanding clauses, whites-only primaries, poll taxes, and of course, violence and intimidation to keep many American men and women away from the polls even after 1920. I think that's to Tom's point. That in the history of law, we're always attentive to the distance or the disjuncture or the gap between the written text and its intention and the way in which that text is implemented, enforced, interpreted on the ground. And in too many American states, this particular amendment, along with the 15th Amendment, neither is read as prohibiting laws, state laws that were designed to keep African American voters away from the polls as long as they didn't expressly use the language of race or gender.
Yeah, Martha, I want to stay with you, and I'd like to bring up the slide of terming Black women the Vanguard. You write about this in your book, how Black women broke barriers, won the vote, and insisted on equality for all, that terming Black women as the Vanguard had a bit of a double meaning. Can you talk about that?
Sure. I come to call African American women the vanguard of voting rights because it turns out when we recover their history, when we recover their ideas, we discover that Black women really were, I'll put it this way, our first anti-racist feminists. They were our first thoroughgoing critics of any law that would constrain political rights based upon race or upon sex. They take up that position very early in the first decades of the 19th century, and they continue to organize, to write, to lobby in that vein, even as they're sometimes allies and sometimes foes, oftentimes succumb to the expediency of sexism or the expediency of racism in political life. Now, if African American women were, if you will, outstanding for holding up those principles, setting that high bar in the 19th century, today in the 21st century, I think we recognize that they were showing us a way forward and, in fact, setting a bar that they hoped the rest of the nation would ultimately catch up to. I'll venture to say that in the 21st century, most Americans would agree, right, that neither racism nor sexism have any place in American law when arbitrating political rights. And this is a value that Black women 200 years ago bequeathed to us. And today we struggle to wholly realize that vision.
And I now want to turn to Julie and the slide from Pauli Murray about equal power for women. Our participants can see that on page 8 of their materials, but we also have the slide of it up as well. Can you talk about that quote, Julie, as well as your own thoughts on the constitutional commitment to sex equality? What does equal look like, and how do these quotes relate to that? I seem to have lost Julie. Is it just me?
I think she's muted.
Oh, I'm sorry. I just want to. I love Martha Jones' concept of African American women as the vanguard. Because one woman who really represents that idea is Pauli Murray, who is a civil rights lawyer, who really invented the idea of Jane Crow and the idea of intersectionality before we started using the word intersectionality to describe the specific or double and unique forms of discrimination that women face because of both race and sex together. And Pauli Murray was actually one of the most important figures for devising a dual strategy that built claims for sex equality on the 14th Amendment and the achievements of the 14th Amendment, while at the same time arguing that there was a need for another amendment, the Equal Rights Amendment. And in part, it was because it was possible to stretch existing equality law in the 5th and 14th Amendments to prohibit sex discrimination. And of course, now Justice Ruth Bader Ginsburg, who often credited Pauli Murray with many of these legal theories, was very successful in litigation strategies that stretch the 5th and 14th Amendments. But what Pauli Murray saw in the ERA is the possibility of thinking beyond equal rights as such and non-discrimination. Because if you think about all of these amendments from the 14th Amendment, the 15th Amendment, and the 19th Amendment, the shall not be denied type language, granted, it's also in the Equal Rights Amendment, but this idea that it's just talking about non-discrimination, when in fact the real reason people want equal rights is for equal power. And that was also true of the 19th Amendment. It wasn't just to have the vote, but to actually have a real possibility of participation in democracy. And I think Pauli Murray really sort of brought that point home by suggesting that what was holding up the struggle for equal rights is a resistance not just to equal rights, but the notion that women and African Americans and African American women were going to be equal participants in determining the future of this country.
I want to now turn to a quote by Frederick Douglass that I think also speaks to this common theme of intersectionality. Our participants can find this in your materials on page 18, but I want to turn to Tom to talk about this idea, as Frederick Douglass stated, that liberty shows that all concessions yet made to her august claims have been born of earnest struggle.
And ongoing struggle. I think that Douglass's quote really epitomizes what we've all talked about, that this is an ongoing struggle. You have to insist upon the words being made real and being made real for all populations of women. And certainly for women of color, these words in the 19th Amendment, as in the 15th Amendment, didn't begin to become real until nearly half a century after the 19th Amendment was ratified. So it is a matter of ongoing struggle. In this area, perhaps more than any other, this is about power, as Julie has a number of times alluded. This is about power. Voting is about political power. And threats to those who are in power have to be real and have to be constant for them to yield progress. Otherwise, the reaction to any threat, even a minor threat or an implicit threat, is to shut down the expansion of the franchise, to do what you can to intimidate and prevent folks from voting who may not continue to support the existing power struggle. I think this is a lesson, Douglass's quote is a lesson for today. Our struggle continues. We haven't yet reached the promised land when we have steps being taken in words not about race explicitly, not about gender explicitly, but steps are being taken to prevent folks from participating. In the current pandemic, we know that there are forces in this country who will do everything they can to prevent an expansion of remote voting or voting by mail, because it is a threat to their political power, even though they know that not expanding the availability of remote voting, vote by mail, means that too many folks, particularly people of color and women, will not be able to participate meaningfully in elections. So even today, right in the midst of this unprecedented time, we know that the struggle to broaden the franchise, to achieve the power that was the aim of the 19th Amendment and the 15th Amendment must continue. I look at the 19th Amendment, and we didn't talk about Section 2, but Section 2, which is also an echo of the 14th and 15th Amendment, says Congress shall have the power to enforce the prohibition on denying or abridging the franchise on the basis of sex. But Congress has never, with respect to any of these amendments, been aggressive about ensuring that that power to enforce has meaning across the country. Indeed, too often, the Congress's actions are to withdraw and allow the states, knowing how that's going to play out in a very uneven manner across the country, let the states decide these issues. But I look at Section 2, and it tells me that that's a part of the struggle that has to continue. To make the entire amendment real means Congress taking that obligation as a serious and ongoing obligation.
And so I want to open up the discussion a little more broadly to talk about how the 19th Amendment has changed America in a broad way, whether it's societally, socially, and politically. What do you see as the legacy of the 19th Amendment? And anyone can jump in.
I'll jump in if that's okay.
Please.
I think that there are two things. It's part of a long turn one that we're probably still experiencing, one that emphasizes the possible role, the potential role, perhaps the necessary role of the U.S. Constitution, of the Congress, of the U.S. Supreme Court in questions of voting rights. That for most of our history and still today, many, if not most, matters related to voting and voting rights are still determined on a state-by-state basis. And we look around in an era of voter suppression, and we can see the uneven patchwork that is this one nation when it comes to the possibility of exercising voting rights in the 21st century. So it's part of that turn to shifting some of the burden to the federal government. I think for me, it's important to say that the 19th Amendment demarcates the beginning of a new movement for voting rights that will certainly take us all the way to the Voting Rights Act of 1965, that is African American struggles, as Douglass would put it, over voting rights begin anew in 1920. And so when we think about the long history of voting rights, the story of women's suffrage is one chapter, but it is linked, particularly for Black men and women, to the next chapter, which takes us to 1965. And so we can only understand, I think, some of those struggles, as well as the struggles we're a part of today, if we understand the unfinished business, if you will, of the 19th Amendment. What the 19th Amendment did not accomplish becomes the burden, the agenda for struggle for many Americans, including Black Americans, in the era after 1920. And we could say that continues today.
So I would just add, of course, that struggle continued for the Latino community, and with the connections that Martha has identified, with the expansion of the Voting Rights Act in 1975 to include Latinos in the Southwest, and that has made it possible to achieve important changes in not just who gets to vote, but the outcome of elections and who ends up in positions of power and authority. But a measure of the work that had to continue, the link that Martha's described from the 15th to the 19th to the Voting Rights Act and beyond, the link continues, the struggle continues, because to me, I sit at the head of an organization that's now been around for 51 years. And I'm proud to say that MALDEF was headed by women for 29 of its 51 years. And two of those women, my mentors, Vilma Martinez and Antonia Hernandez, did all of this important work on voting rights and creating opportunities for Latinos to be elected, except that the vast, vast majority of Latinos being elected were men. So women were leading MALDEF and creating opportunities that were by and large opportunities for Latino men. That's beginning to change, of course, and that's critically important. But that long line of struggle and continuing work, it's organizing, it's about resistance, it's about action in courts, in legislators, and out in the streets that continues to be required to make the 19th Amendment real as the other amendments. I think the 19th Amendment, like any good progressive piece of legislation, is an inspiration to that ongoing struggle. It starts to change how people think about issues. Any child who reads the 19th Amendment is going to have a different view about the rights of the sexes in this country. And I think that's the kind of inspiration of ongoing work, ongoing struggle that the best laws inspire.
Yeah, and on that point, please. Go ahead.
Well, I think that it's important to evaluate the success of the 19th Amendment based on the broader equality goals and the goals of women's empowerment. But I think that's always been an interesting question. I think Tom was saying earlier in the conversation that women got the vote, but you don't see a lot of women or women of color being elected to Congress right away. And certainly at the time, women got the vote, but it was not really clear whether or not the 19th Amendment changed language in the Constitution that refers to the President of the United States as a he, and members of Congress using he. I think some scholars just assume that once you got the 19th Amendment, he became he or she, but that's not clear. But in any case, we didn't have a lot of women elected to Congress, even though they did run. And a lot of the women who were in Congress between 1920 and the early 1970s, a good number of them were widows of male members of Congress who were elected in special elections or appointed to office. And even in 1970, when the Equal Rights Amendment gets off the ground, women are only 2.4% of Congress. And today we're at an all-time high. That all-time high of women in Congress is 23.7%, which is significantly lower than many other constitutional democracies around the world. And on the one hand, I think we should be proud of the progress of getting to 23.7%, but it's also important to note that 23.7% is not even enough to block a constitutional amendment. You need 2/3 of both houses of Congress to get a constitutional amendment. So if you don't even have 1/3 women in Congress, that's the kind of dangerous imbalance of power that Pauli Murray was talking about. And then it's not just representation in positions of power, but also policy issues around the things that make a difference to women's economic and political participation in American society. And I think it is important to bring those things in as we evaluate what the 19th Amendment accomplished.
You know, Tom was talking about resistance and organizing, and I want to ask you all, start with Martha. Is the fight for women's suffrage a social movement? Was the 19th Amendment the tool of a social movement, and how was it inspired by other movements? How did it inspire movements we see today? I'm not sure everybody thinks about it in that way today. What do you think?
I think that's a great question. There's no question that the road to the 19th Amendment is framed as a social movement, that it uses and initiates what we recognize as social movement tactics, particularly the extraordinary political theater led, sort of overseen by Alice Paul and what ultimately is the National Women's Party. On the other hand, it's very difficult, I think, in the early 20th century United States to speak of a social movement without recognizing how profoundly fractured American society itself is. And so, in my view, there's more than one social movement afoot in the early part of the 20th century. Those organizations that are coalescing around what is called women's suffrage is certainly one of those movements. But the women I write about, African American women, are as much a part of organizations like the NAACP and the National Urban League. And so their movement, if you will, is more difficult to discern because it doesn't take a sort of clear cut institutional form. Black women make politics, in a sense, in the way Julie is alluding to, moving between suffrage organizations, women's clubs, their church communities, civil rights organizations, sororities, all, frankly, toward a shared end, which is equality, dignity before the law. And so partly we'd need a better social movement theorist than me to quibble about the term, but it's important, I think, to highlight the ways in which movements do not only take form through singular issue or streamlined organizations, and Black women develop a kind of nimbleness moving in between and from one to the other as another way of building social power and political efficacy.
Tom, what do you think about this as a social movement? I'm reminded, just looking at the notes here that the word demand was used not only by John Adams, but also by Frederick Douglass and Susan B. Anthony. The word demand showed up in all of that, perhaps with a different meaning, depending on the speaker, but that sort of sounds like a social movement to me.
Yeah, to me, a social movement means this is action, this is organizing that occurred community by community, sometimes neighborhood by neighborhood and house by house. An incomplete social movement, to be sure, but to have success on the lines of the 19th Amendment, it would have to be a social movement. I think all of us understand, even I, as a lifelong, career-long civil rights lawyer, inspired, like so many of my colleagues, by the foundational victory in Brown versus Board of Education, I recognize that litigation isn't going to achieve the legal change. Litigation can contribute to a social movement that is about changing hearts and minds, and that's an ongoing effort. You really have to ensure that there's buy-in by everyone as broadly as possible to achieve the change we need. That's why it's an ongoing struggle of organizing and action and demands, because you've got to continue to ensure that minds are changing to achieve the kind of transformation that the 19th Amendment and so many of these other amendments looked to achieve. So in my mind, it is clearly an ongoing social movement, as Martha's described, hopefully over time, social movement that is becoming more and more inclusive and with a broader theory and actual action to achieve that broad and inclusive vision that lies behind the 19th Amendment.
I want to say that I do want to leave some time to get to questions from our attendees. We have some very good questions have been asked already, and I want to get to that soon. But I also just want to finish up our panel discussion by thinking about the 19th Amendment and how it should be commemorated in its centennial this year. Why does it still matter? Julie, why does the 19th Amendment matter 100 years later?
Well, I think the 19th Amendment was the first important step towards recognizing women's equality in the Constitution. And I think today in 2020, the Equal Rights Amendment has completed ratification, although a cloud of uncertainty hangs over the Equal Rights Amendment because of questions about the enforceability and the validity of the deadline on ratification. But I do think that the reason it's really important to commemorate the 19th Amendment today is that it says something, and relating to this earlier question about social movements, it says something about constitutional change and what's possible. And the fact is that we exist in the Constitution. If you're going to have a bloodless revolution, you go through the process of constitutional change, which the Founding Fathers made deliberately very difficult in Article 5, 2/3 of Congress and 3/4 of all the state legislatures. And when you're going to expand the boundaries of who's counted in We the People, whether by ending slavery and enfranchising African Americans or by enfranchising women and recognizing their equal rights, I think that Article 5 process is one that's very hard and takes a long time and cannot be achieved by a single issue social movement alone. One of the things that helped women's suffrage along was not only the movement for racial justice, but also another movement for prohibition, the Women's Temperance Movement, which had the largest, the Women's Christian Temperance Union, the largest organization of women, political organization of women towards the end of the 19th century. And what that means is that you get a lot of different voices coalescing to make it possible to have change, but some of those voices also sometimes limit what that constitutional change can achieve. Like if you think about 2/3 of Congress and 3/4 of state legislatures, it may not have been possible to get a 19th Amendment without bringing along Southern segregationists and people who had radically different views about what it should actually do on the ground and in real life.
Yeah, Martha, how should we commemorate the 19th?
I'll say at the start, I'm very glad that I'm a historian and not someone charged with commemorating this amendment.
Why does it still matter?
It certainly matters because today, unequivocally, we recognize the force of American women broadly. In my research, African American women in 21st century politics. And this anniversary gives us an opportunity to fully appreciate that a figure like Stacey Abrams or Ayanna Pressley, these are women who do not come out of nowhere. They do not come out of whole cloth. They come out of a long history of women's struggles for political power. Listen to them narrate their own stories, and they'll tell you how they are deeply inspired by some of the earliest Black suffragists in this country, figures like Sojourner Truth or Harriet Tubman. And so I think in order to be a smart student of 21st century politics, this anniversary gives us the opportunity to be even smarter by appreciating the history of how we got here.
Yeah, I will note that Congresswoman Pressley even told me that her cat is named Surgenor Truth. So clearly,
thank you for telling me that.
She calls her Sojo. Tom, you get the final word. Why does the 19th Amendment matter so much now?
I think it matters because we have to recognize how many issues today are gendered issues, and we don't always do that. I think we need to recognize the important steps that need to be taken to enforce the principles of the 19th Amendment. I'll give just two examples. Our immigration flow to our southern border has changed in recent years. It used to be dominated by single men. In really the last decade plus, it has changed. So there are many women who are approaching our southern border with their families in an attempt to escape really dangerous, violent conditions. And we don't talk about that as an issue of gender equality, and I think we should. That the change in the immigration flow is real, it is defined by gender, and we ought to be evaluating the policies that are being put in place against opposition often, but really without enough discussion of these issues. And the second example I'll give during this pandemic is to remember the women who are farm workers in this country who are performing an essential service, in addition to the many women performing essential services in our cities, but out in our rural areas that don't get as much attention as we focus narrowly because we can't travel in the way we used to. But I think of farm worker women who are subjected regularly to unsafe, really discriminatory conditions, and a lot of that is amped up in the time that we're facing. So to me, the best commemoration of the 19th Amendment is to take a close look at all of these issues and how they are, if not dictated, at least influenced still by our notions of gender and gender inequality in this country, and take real steps to continue the struggle that we've talked about to make the 19th Amendment real.
I want to get to some of the questions that we've been receiving along the way. One is about the Equal Rights Amendment, which has come up a couple times already. Linda asked if there is your views about the likelihood of it getting ratified. Julie, I think you mentioned this, that it got the ratification from the states, but there's a timing issue at play.
So we're at an unprecedented moment in American constitutional history. The Equal Rights Amendment is the only amendment that was actually written by women and then adopted by some women who were in Congress and ratified by women in state legislatures who led the effort and achieved 38 ratifications consistent with Article 5 and has met all the requirements of Article 5. But is being held up because of a congressionally imposed deadline. The Supreme Court has long recognized Congress's power to put time limits as well as not put time limits on amendments. And the House moved this year in February to remove the deadline. The Senate has not voted to remove the deadline as of right now. So I think that if the Senate removes the deadline, it would be very crystal clear that the ERA is part of the Constitution. There's ongoing litigation as to whether it's necessary for Congress to remove the deadline. And so, and I think there's a variety of views on that question. But I think overall, this is an amendment that has taken generations of women in constitution making to give meaning to and to make. And I think that it is something that really signals the empowerment of women, because I think it would not have been possible to get it to the point where it is, where you had 3 state legislatures from 2017 to 2020 completing ratification, led by women, and particularly women of color in those state legislatures, and very vocal women in the House giving speeches and leading the effort to vote on the removal of the deadline.
I have a question from Lydian. Do you think that convicted felons should have the right to vote? I think that gets us back to our opening quote from John Adams about how broad this guarantee is. What do you think? What does the Constitution tell us about that?
Well, I think there's a strong movement to ensure that convicted felons do have the right to vote, and they do in a number of states across the country. It is really telling that the states where they continue to deny a right to vote to so many who have been convicted are states where there have been historical problems with broadening the franchise. Once someone has completed their sentence, if not before, it's quite clear that they should have the right to vote, the right to influence the very policies that may have ended up really playing a role in their being incarcerated in the first place. So I don't think there's any question but a commitment to the principles behind the 19th Amendment would suggest that, in fact, convicted felons should have the right to vote.
There's a question here from Sharon. What's been done to be inclusive of African American women and Hispanic women since the 19th Amendment was ratified?
Well, we've touched on the very important Voting Rights Act of 1965 and its amendments that extend to communities of color across the nation, men and women, the right to vote in many places for the very first time. Congress now puts in place a set of robust tools that today have been, Tom, is it too strong a word to say eviscerated? This is your area of expertise.
That's a fair characterization. That's
Thank you. Which is to say that the U.S. Supreme Court has undermined that powerful intervention into the voting rights of both Black and Latino women in the United States. So we here sit in 2020 facing too many schemes aimed at the wholesale suppression of those votes without the kind of oversight and check that the Voting Rights Act had once provided. It's to say that this isn't a story of progress at all. I don't think the story of voting rights. It is really a story of very uneven, a very uneven story, one in which we can backslide, if you will. And I think we are sitting in a moment where we have moved backwards rather than forwards when it comes to voting rights for women of color.
I agree.
Do you want to jump in? Yeah.
I agree with what Martha has said. I would just emphasize, though, something that she also talked about previously, which is the importance of the ongoing agency and leadership of African American women and Latino women in working to change the situation that we face. I talked about leadership of my organization, but I'm struck really throughout the country as you look at who are the lead plaintiffs in voting rights cases, name the issue, whether it's about voter ID or about voter registration requirements that have not been imposed previously, or it's about voter purges, or it's about creating electoral systems that are truly inclusive. It's often women, Latino women from the community that I represent, and African American women who are in the forefront of challenging this evisceration, this undermining of the protections enacted over 50 years ago in the Voting Rights Act. And I think that's important to recognize as well. We are in a time of ongoing struggle, and I'm certainly really encouraged that we have women of color in the forefront, whether you're looking at the women in Congress who have particularly drawn the ire of our president, whether you're looking at who are not just the plaintiffs, but the lawyers in many of these cases. We had a landmark achievement in challenging Kern County, California a few years ago, and MALDEF's entire legal team was made up of women lawyers. So I think it's important to recognize that the legacy of the 19th Amendment continues in the agency and leadership of women of color to make it, once again, more real, as is the constant struggle to make it more and more real.
I'm going to go to one last question. We had so many good ones, but we're running short on time. But it was from Cornelia. What were the arguments of the anti-suffragists? What are the current arguments of those who oppose the ERA? Julie, do you want to start?
Well, I think I'll start with the arguments of those who oppose the ERA. I think that the time limit is being used to hold up the ERA on the grounds that it's a game, that there are rules of the game that aren't being followed if you don't enforce that time limit. And I think in some ways the time limit is a way of using procedure to avoid a substantive debate on a principle, a constitutional principle that men and women have equal citizenship stature, which really should be, as even Ronald Reagan put it in the 1970s, morally unassailable. And of course, the concept of equal rights is going to have a lot of different interpretations that are going to be fought out in the political arena and to some degree in the courts. But the idea that you don't want the principle enshrined, right now, most of the arguments focus on the deadline, and some of the arguments focus on the success of the movement for equal rights. That is, some people say we don't need an equal rights amendment because the 14th Amendment and the 5th Amendment embody the principle that sex discrimination is illegal. And I think that while it's true that we've gotten to a place where the 14th Amendment does do a lot of work in protecting women from sex discrimination, to say that that's why we don't need an ERA is to erase the history of women's organizing, dating back to even before the 19th Amendment. There were always arguments not only for the vote, but for equal rights in all aspects of life and under the law. And I think that not having an ERA is a failure to recognize women's contributions to constitution making. But I think that there's a tendency of those who oppose it to really make it about specific political issues, which will always be contested.
Yeah, any thoughts about the anti-suffragists?
Well, I'll say that if we just roll back for a moment to the early part of the 20th century, anti-suffragists are an important dimension of the political scene. Men and women who argue a range of things, from the sort of inappropriateness of women at the polls, voting and political work as somehow undercutting womanhood or their status as ladies, the suggestion that women are not suited to politics, their minds, their bodies, their spirits, not robust enough for the rough and tumble of politics. These are arguments, of course, without much of a foundation, but they are made nonetheless. The thing I would add is an argument is made that there's no need to enfranchise American women because they will simply vote as their husbands have voted. That is to say, their votes will be duplicative. It will not move the needle on any particular election and in any particular contest. And so here, American women face the test, right, of the 19th Amendment after 1920 to establish whether indeed they have a distinct political identity. Here, historian Leah Gidlow has been looking carefully at the voting behavior of African American women after 1920, and demonstrates that Black women do indeed become a voting bloc, and a forceful and increasingly forceful and effective one after 1920, even as many are disenfranchised, because they continue to work in political coalition and consolidate and use their voting power collectively. We all remember today the effect that African American women voters had in Alabama's special election, during which Senator Doug Jones was elected. That was the 98% of Black women coming to the polls in concert and tipping that election in favor of Jones.
Okay, well, an hour goes by quickly when you have such a great discussion with great panelists. I thank you for that discussion, and I'm going to turn it over to Pamela Roberts, who is the National Law Day Chair of the ABA, for some closing remarks.
Well, thank you, Kim, and this concludes our virtual Law Day 2020 public program on the 19th Amendment and its legacies. I have had the privilege of serving this year as the ABA National Law Day Chair, and speaking in that capacity, I thank Kim, our wonderful moderator, and all of our fabulous panelists for your insightful and provocative discussion today. It's also with deepest gratitude that I thank the Law Library of Congress for its partnership in this virtual program. The ABA's Division on Public Education coordinates National Law Day programming and resources. So today's program has been recorded and will be made available to all that missed it or who would like to watch it over again. And for more information on that, I direct you to lawday.org. Also, watch in your emails. We will be forwarding links on further 19th Amendment resources, and that will be coming from the ABA and the Law Library of Congress. And included in those links will be a Law Day interview between Law Librarian Jane Sanchez and ABA President Judy Perry Martinez, whom you heard from today. So watch your emails, go to the website, and again, thank you for joining us. Please be safe and well.